keep going. Let's get the, Suncoast Transit case versus Moore.
May it please the court, counsel, my name is Jeffrey Jensen. I represent the appellant, Nelson Coast Transit Authority. In this case, the parties agreed that reversible error occurred. What is disagreed is what the court should do about it. Should the court agree that there was reversible error? And that issue is the issue of sovereign immunity. Nelson Coast Transit Authority is an independent special district of the state of Florida. And as a result, Iowa Florida Statute 768.28 subsection 6, pre-suit notice has to be served both on the Transit Authority and Department of Financial Affairs. In this case, the plaintiff alleged that they did so. The defendant specifically denied that allegation. In addition, but an affirmative defense that specifically stated that plaintiff failed to comply with the pre-suit notice provision of 768.28.
And you're complaining here on how the court dealt with the motion for directed verdict
Yes, Your Honor, but
by reopening the evidence?
by reopening the evidence, and then on top of that, both parties had requested a jury trial. There's nothing more sacred to our system of justice than a right to a jury trial. What the trial court did was conduct an impromptu bench trial. Heard testimony from heard testimony from witnesses, took in exhibits and evidence, but then never issued a ruling.
And would you agree with me that courts in dealing with the conditions proceeding on the pre-suit notice that encourage the parties to deal with this pre-trial motion before trial?
That is the preferred method of doing so. But unlike,
Probably for the reason of what happened here.
as my colleague cited in her brief, 768.28 subsection 7, which requires that be brought up pre-trial, that is not a requirement of subsection 6.
But are you disagreeing that the notice was given?
I'm not disagreeing that notice was given, but I'm disagreeing that I think the court should have directed a verdict for the authority, because plaintiff never listed a witness on a witness list for purposes of pre-suit notice, never listed any exhibits, and during the impromptu bench trial, never properly authenticated some of the documents.
Let me just hypothetically here. Let's say the court reserved on the DD, which or did in one of the rulings, and they're now on notice that they didn't do the pre-suit, so they're going to figure out how to try to get that evidence in, right? And you don't disagree that the notice wasn't given.
I don't disagree that notice wasn't given.
So how is this going to change anything if the issue went to the jury?
If the issue had properly went to the jury, it was in the jury's discretion to determine, yes, you did this, or no, you didn't do it, or if the court, as a matter of law, determined that they did meet that
And
burden.
I just don't see this as a gray area. I'm looking at the exhibit, I think it's 23, and it's stamped received from the county attorney on, I think, September 21st or something like that. So I just don't see this as an issue that the jury would even be grappling with when they see that it's stamped received from the county attorney. So I don't know why we're wasting our time here on it. So why don't you make your other?
If I may address what you just raised, Nelson Coast Transit Authority is not the county. The fact that the county received it, it was sent to the wrong agency. So that is not proof. They did not meet their burden of proof. And the jury.
But again, you're not disagreeing that your client did an improvement.
That's correct. I'm not disagreeing that my client received. I don't know whether or not the Department of Financial Affairs received it, because that's not something that I have contact.
But we did have, I mean, in addition to the stamp receipt for the county attorney, and I appreciate your comment. We had the green cards, which were the return receipt.
Which were never properly.
Okay, I understand that. At the close of their evidence. Until they reopen. Don't you really need to be arguing that there's some abuse of discretion for the court to reopen the evidence? At that point in time?
I would argue that if the court had reopened the evidence, allowed all this evidence to be received in front of the jury, so the jury can make a determination. But the trial court had absolutely no authority to take that away from the jury. The only time you take something away from a jury is via a summary judgment before trial or to a directed verdict at the close of evidence. The trial court did neither. It had an impromptu bench trial in the middle of the jury trial, and then it never issued a ruling. And the jury was never given any information. Who was the true finder of fact for this issue was never given any evidence to support a ruling that they or a jury verdict that they did in fact comply with the statute. And I believe because of that failure to prove that, the trial court should have directed a verdict for Mel Santos transitory on receipt notice.
Mr. Jensen, did you want rebuttal?
2 minutes.
Got it.
Now, if the court determines that this case needs to be tried again, I just want to briefly touch on some issues. My colleague and I agree that the trial court erred when it determined that Dr. Bain didn't have an engineering degree.
Can I interrupt you for 1 second? When you said that both sides stipulated to error, didn't that stipulation include the remand for a new trial? What about an expert who didn't have a credential?
Both sides agree that Dr. Bain was qualified to issue the opinions he did, and it was error to keep out those opinions. I think that merits, I think the case law is clear that merits a new trial if the court doesn't agree that it should be a directed verdict.
What's the other side view of that?
The other side's view of that is, in fact, that the trial court committed error when it determined Dr. Bain didn't have an engineering degree and was not qualified to opine in the area of biomechanics.
I think they do agree to a new trial, it's on the one expert on bona fide.
I don't think they didn't dispute anything, the contention regarding Nicole Bonaparte. They simply said, yes, we agree the court made an error when it determined that Dr. Bain didn't have an engineering degree. He should have been permitted to testify. That was all it was said.
So you're saying the stipulation doesn't go the extra yard, doesn't explicitly say, and they get a new trial? How do you cure that mistake that they stipulate to if you don't give them a new trial?
That's the only way to cure it is for a new trial. Now, the parties disagree on the aspect of the sovereign immunity.
Well, that's a separate issue.
Yeah, that's a separate issue.
Is that really right for this appeal that you get a new trial on the evidentiary matter?
Well, what this court should do is to first determine whether or not a mistake was made on the sovereign immunity issue and what the consequences of that mistake was. If the court decides that because they didn't meet their burden of proof, that it should be remanded to the trial court with directions to enter judgment in favor of the defendant on that issue, then there would be a need for a new trial. If the court determines that it's not necessary to go into the sovereign immunity, then the issue becomes the errors that were made during the trial. First of which was with Dr. Bain. Dr. Bain has an engineering degree, he has a medical degree, he is a certified accident reconstructionist, and he has.
And let me just read from the brief, from the answer brief, in the summary of the argument. Ms. Ford agreed that the matter should be reversed and remanded for a new trial. So they agree for a new trial, it's solely on the issue of.
Correct.
I don't think that you said that.
If I misspoke, I apologize. We're in agreement with that. However, what wasn't said and what we do believe that we've met is we had a Daubert here, Dr. Bain, and I believe the evidence established not only that Dr. Bain is qualified, but his methodology met the Daubert standard. So if this case is remanded back, not only, I don't believe there would be a necessity to redo the Daubert hearing, because I think all the evidence that was necessary to meet that burden was proffered during the Daubert hearing. Like with Ms. Bonaparte, the court never held an evidentiary hearing on Ms. Bonaparte because it didn't have time. What the court essentially did was hold counsel for parties. Hey, I'm giving you each 5 minutes to make your best arguments, and that's all you get. Never heard any evidence. And what the trial court did is it came out with factual findings that were unsupported. So if this case is remanded, what we need to do respectfully is have a full Daubert hearing on Ms. Bonaparte, because that was never done. And as a result, her opinions regarding the market value of the medical treatment Lincoln had was never heard by the jury.
Did the court have at the Daubert hearing the addition of Ms. Bonaparte?
I believe the court had the benefit of the deposition of Ms. Bonaparte and also the deposition of Dr. Ziti, who is also a medical doctor and medical coding expert, who confirmed that Ms. Bonaparte did the proper analysis and that her opinions are supported by the general medical coding community and the prevailing literature in that area. Lastly, during the trial, there were some improper remarks. I think any one of these would have been reversible error, but cumulatively, they definitely deprived Alan of a fair trial. First, it occurred with Dr. Shim. Dr. Shim reviewed his medical records and diagnostic films and testified to his medical opinions based on a review. Plaintiff properly brought up that, well, Dr. Shim, you never actually examined plaintiff, did you? No, I did not. And that was a proper question. But what was not proper was for plaintiff to say, in fact, the authority hired you all the time to perform compulsory medical examination. You were not hired to do one in this case. That was a criticism not of Dr. Shim's opinions, but was a criticism of Alan's handling of his litigation. There are many reasons and many different devices discovery that a litigant utilized, and a litigant's decision to employ one form of discovery versus another shouldn't be criticized to the jury.
Was there a motion to eliminate, address that issue, or it came up during trial?
That came up during trial. There was not a motion to eliminate.
So if there's a remand, it's probably going to be the subject of the motion to eliminate.
Yes. But what I'm concerned about, Your Honor, is if this court doesn't issue a ruling on that, there will be no guidance. But as far as I'm aware, that's a novel situation that's come up.
We don't know what the proof would be on remand. That's the problem with asking for too much guidance. Hands are tied by trial if it unfolds.
The other error that occurred with Dr. Shim was plaintiff's statement. Well, plaintiff's treating physicians should be believed over Dr. Shim, because plaintiff was trusting her physician to be honest and truthful. That's a comment on the witness's credibility, which parties or their counsel should not be allowed to make. Second, our physicians could be sued for malpractice, where the authorities expert should not. Malpractice has nothing to do with an expert credibility, and the jury was given no instructions about the burden of proof of malpractice, where it would apply and not apply. I believe that was error. Second issue was with Dr. Foley, who was a radiologist. This court has previously held in Milburn versus State that a party shouldn't bring up a party's opposing party's prior retention of next. In this case, during opening statements, Appellee's counsel told the jury, Well, and by the way, we hired a radiologist at the authority hires. And then that also came up on direct during Dr. Foley's testimony. Now, I can see a situation where if we attack Dr. Foley's credibility by saying, counsel isn't true, counsel plans to pay you $1 million over the last 2 years, and on redirect, it might be appropriate to say, well, isn't it true, counsel for defendant has paid you $1 million. But it's improper bolstering when there's no attack on a witness bias or prejudice. You just bring up the fact that in the past, the opposing party has hired that expert. It was also inappropriate for appellee to argue, closing an argument that injured people shouldn't have to pay out of pocket for medical bills. That was an attempt to suggest to the jury that Ms. Ford had no insurance. And it was also an appeal to the jury to relieve Ms. Ford of the financial burden of her medical treatment without consideration of fault. If this case, Freno versus Resnick, which was cited in the brief, says the subject appeals were blatantly prejudicial. And lastly, during closing arguments, trial counsel for appellant made a comment on the evidence. There was photographs of Ms. Ford doing some gymnastics. And counsel remarked, look at these photographs and then look at the medical records. Medical records indicate that plaintiff has an obesity problem. That's not reflected in these photographs that were presented to you as being representative of a pre-accident condition. So it's our position that these are old photographs. In closing arguments and rebuttal, the trial counsel for appellee said, according to the authority, this board is a fat liar. That's an inappropriate comment that was intended to inflame the jury. If this had been a defense verdict and the authorities counsel called Ms. Ford a fat liar during closing arguments, I don't think the court would have had a problem reversing that inflammatory comment. And I think it works both ways, especially when counsel for the authority had made no such statement. And if there are no questions, I conclude the presentation.
Very good, interesting. Comments?
No, Catherine Williams.
Okay.
At least, I do want to confirm, we have agreed that should be amended to the time. Court made the narrow fact in stating that Dr. Bain did not have an engineering.
Well, what is a new trial? All issues, partial issues, what, is there more to the agreement?
New trial on all issues, but we agree. That expert is, I have to concede that
They accept the stipulation.
there was no discussion of the stipulation except what Judge Smith read from our brief. My conclusion is should be removed from the trial.
Why are we here?
The only reason I am here is to point out that defendant's PPSA's argument that judgment should have been entered in its favor on sovereign immunity issue should be a non-issue. I want to read one statement that was made by Mr. Jensen during the argument after the trial court reopened evidence to get testimony from the lawyer who sent the letters that issue. Mr. Jensen, I am backing off the legal insufficiency. The court. So he's, as I understand it, abandoned the legal deficiency of the notice. Is that correct? Mr. Jensen, that is correct, Joe. The only contention here is the manner in which the trial court addressed that would be any surprise or prejudice.
Well, I mean, aren't they arguing that whether or not the STA received it? I mean, I understand that the deficiency is a little different than the receipt.
Let me point out the statute as read by the trial court. The trial court did make a clear ruling. Mr. Jensen commented earlier, the trial court never made a ruling. It's on page 717 of the transcript. Court finds that the testimony that was presented today is sufficient to show compliance prima facie with the requirement of the statute. Further found no surprise. The statute itself focuses on provision of notice, not receipt by the agency. And that is actually something in 6B. It says these are not elements of cause of action of negligence. And the Florida Supreme Court in 2011 in the economic said this is something that is burden of proof for the defendant. If there is an issue, they have to plead it with specificity and particularity.
So long as the notice had the proper party and the proper address, then it was sufficient that as long as they put it in the mailbox.
And receipt confirmed by certified mail return receipt green card, which is what the co-counsel for the plaintiff was called. Yes, this is the letter came to my office. This is my business record. This was sent by my office. Green cards came back to my office. And he also testified that the agency, responded. So they received notice. The question of receipt of notice was not an issue, and that was conceded at the trial. So when the statute focuses on notice, not provide any right for jury trial to decide. I mean, some courts resolve technical issues on directed verdict all the time. I mean, of course.
So how are we, so if we reverse remand for a new trial, how do we grapple with the issues that have been raised on the appeal that Ms. Ward doesn't address when we have cases that say failure to address an issue results in waiver? So
I agree, I have waived that. And I can't go into the reasons why we did that. But we have waived the right to do that.
okay.
I'm not fighting it. The only point I'm fighting on is
The sovereign immunity.
that they should not have judgment entered in their favor on the sovereign immunity issue, especially when they've already conceded that the notice was insufficient. And the only question, the only dispute is either it comes down to the manner in which the trial court reopened the case to do so, and I said that they did not abuse, the judge did not abuse discretion in doing so. That what he did was necessary to have see justice done, especially when they conceded that the plea was sufficient. And then the point on directed verdict, the trial court did deny directed verdict on the defendant's third affirmative defense. It's an affirmative defense. It was denied. The ruling was made. There is nothing wrong with that. It was resolved for certain. I mean, it's clear and outright in the record. There's no need to have it submitted to the jury. And during trial, the defendant never even attempted to argue that it should be in jury instructions or added to a verdict. They just renewed their motion for directed verdict. Close of all evidence that it was denied for the same reason.
So is the issue stipulated to disposition of the appeal, or does this court need to go further and address the sovereign immunity issue?
I think the issue, if the opinion were to be remanded for new trial, that is all that you need to say. Because what is asked on the sovereign immunity issue, the appellant is asking for an affirmative judgment entered in their favor on the entire case.
But that's a factual dispute. Does that relate to a factual dispute?
I think that's actually an issue of law, the number
Only a issue of the number.
on the sovereign immunity, yes, because they conceded the
Why didn't they
insufficiency.
summary judgment on that?
I. No,
Are they right?
no, they're not.
Why do you disagree? Won't you write reasoning again?
Disagree on what point
On
you're
the
on.
remand, sovereign immunity, knocking it out in their favor.
I'm sorry, I'm not
You're
understanding.
saying they want sovereign immunity reversed in their favor.
They want judgment entered in their favor.
And you want a trial on sovereign immunity?
I want a new trial on all points. And the sovereign immunity issue is an affirmative defense that would still be in the pleading, that would still need to be resolved. I think by conceding that the notice was legally sufficient, I think that would be a very quick motion that would be resolved before you ever got to trial. And the fact that we now have testimony under oath from during trial confirming that notice was sent from the plaintiff's counsel's office and green card received. I think that's a very quick motion
Is
for
that a
summary
factual
judgment.
dispute? You're saying a factual dispute or a legal dispute?
The question of whether judgment should be entered is.
No, no, it's a question of whether the notice was received.
Question of whether notice is received is a, but for their agreement during trial that it was received and is sufficient. Actually sent, the statute focuses on it being sent, not received.
And sending is a test, not received.
Notice must be provided.
And just so we're all clear, sending isn't just like putting an envelope and a stamp in the mail. It's return, it's certified return receipt,
It was, and the fact of receipt,
which is why the courts don't focus on receipt. Because it can sit at the post office until someone a month later decides to go pick it up.
in this case, co-counsel at trial testified. We sent it, and we got the green card back.
Yeah, so isn't that an issue that we have to decide because the issue has been teed up for us to decide and it's somewhat dispositive? If we, find for the appellant, then you're out, right?
If you find for the appellant on the
On
sovereign
sovereign
immunity
immunity
issue,
issue,
yes, because
right?
they're asking
Yeah,
for
so
judgment
it's
to
a
be entered in
dispositive
their
issue
favor,
that we have to deal with.
which, and that turns on the question of whether the trial court used a correct procedure. Because legal sufficiency was proven and then conceded. So the trial court did not err by reopening the case and taking evidence. He made specific findings that there was no prejudice, no surprise. And then denied directed verdict on the affirmative defense. I don't know what more the trial court could have done. I mean, he made an explicit ruling that it was, notice was sufficient, and then denied directed verdict.
So it's somewhat of a hybrid. It's use of discretion whether or not the manner in which you reopen the evidence to allow it, and then making the determination then would be de novo. Is that what you're saying?
I would not disagree. But as a matter of law,
Right.
and
Yeah.
by doing it through directed verdict as opposed to sending it to the jury, that is a matter of law because of the statute, the need for strict construction of the statute. It is not something that has to go to the jury. There's no requirement in the statute that it goes to the jury. Unless you have further questions. Remand is necessary.
Can you break down for us as far as on the issue of the sovereign? You also agree that it's a positive issue that we have to decide regardless of whether it's stipulation or your agreement remains for new trial.
I agree, absolutely, it's positive. The Conda case, not applicable in this matter, because that is a completely different section of 768-28. It's clear from Sheriff of Orange County versus Bolte, which is cited in the brief, that this is a issue for the jury. Whether or not a litigant complies with pre-suit notice conditions of 768-28 is an issue of fact. And all issues of fact pursuant to the Florida Constitution and the U.S. Constitution require jury determination from both sides requested. The only means of taking that away from the jury during a trial is through directed verdict.
And so just so I understand, because I don't know that I'm quite getting the point, why, what is the issue going to the jury?
The jury,
Because you don't have a disagreement as far as whether the notice was due.
well, the
I
jury,
don't know what the objection to is. To the notice.
the objection, Your Honor, is simply that the jury is the appropriate finder of fact. And when a motion for directed verdict, such as Alan's motion for directed verdict, is denied, That means the issue goes to the
I
jury.
know, but I'm not seeing the issue, when you agree on the record that the notice was sufficient.
Yes, we agreed on the record. However, we disagree that it was properly raised at trial to begin with, since there was no witnesses designated, no exhibits designated, and the issue was handled
Your
via.
time just expired, but I'm gonna give you another 30 seconds to finish it.
Thank you, Your Honor. And because the issue was tried via a bench trial, not a jury trial, on both sides of the main jury trial. Thank you for this time.
Thank you. Okay, another full next case, let me just confirm. All right, the next case would be Barry Nolan versus Tennessee. Be that to the one.